Hello everyone. The topic we will discuss in this lecture is from Jurisprudence, and the name of the topic is Different Kinds of Liabilities. Different kinds of liabilities. So the first point we will discuss is civil liability. So what is civil liability? Civil liability is the enforcement of the right of the plaintiff against the defendant in civil proceedings. So you can ask this question: who is a plaintiff? Who is a plaintiff? So a plaintiff is a person who brings a case against another in a court of law. And who is a defendant? A defendant is an individual sued or accused in a court of law. So we are talking here about civil laws, that is, the system of law concerned with private relations between members of a community rather than criminal affairs. So civil liability gives rise to civil procedure whose purpose is for enforcement of certain rights claimed by the plaintiff against the defendant. So to make it clear, let me cite one example here. Let's say A and B made a contract between them. Let's say A is the landlord and B is the tenant. It was agreed by both A and B through mutual agreement that B, the tenant, can live in A's property for 2 years. Let's say later on, after 1 year, A, the landlord, changed his mind and told B, the tenant, to evict from the property. So here B is the aggrieved party because A violated the contract, or we can say did breach of contract. Let's say for relief, B filed a case in the court of law against the landlord A. Here B has become what? B has become the plaintiff and A has become the defendant. So as the case has been filed by B, the plaintiff, what is the reason behind filing this case? B filed the case for the enforcement of his right to stay as a tenant in A's property for more 1 year as per the contract. As the contract made between A and B was for 2 years, and after 1 year, A wanted to evict B from his property. So here, for the breach of contract, civil liability will be upon whom? Civil liability will be upon A, the defendant, through proper compensation to be paid to whom? Through proper compensation to be paid to B, the tenant. So, examples of civil proceedings are an action for let's say recovery of debt, restoration of property, the specific performance of contract, recovery of damages, etc. Okay, like for example for motor vehicle accidents, we are having the Motor Vehicles Act of 1988. There are provisions for accident claims also. So many examples can be cited in this regard. But the main objective behind filing the case is to enforce what? Is to enforce certain rights claimed by the plaintiff against the defendant. Okay. So this is important to be noted for civil cases. We are having Code of Civil Procedure 1908. Now let us come to criminal liability. What is criminal liability? The second point, criminal liability. So criminal liability is the liability to be punished in a criminal proceeding. Criminal liability is the liability to be punished in a criminal proceeding. So let's say A committed a murder. Suppose A committed a murder. A murdered B, suppose. So as here in this example, A murdered B. Two things are vital to be noted in this regard. The first one is mens rea. which is the mental element of a person's intention to commit a crime. Mens rea, which is mental element of a person's intention to commit a crime. And secondly, we have to see actus reus, which is the guilty act, or we can say guilty action. So here in this example, as A murdered B, it will be seen whether A murdered B with a guilty mind, such as pre-planning with full intention to kill him, which is the mens rea. Whether mens rea, whether it was present or not. Okay. Secondly, as the murder has been committed through an act, like let's say A murdered B with a gun. So this murder is the manifestation of that guilty mind or criminal intention or mens rea. So if there was mens rea while murdering B, A will be punished under section 302 of the Indian Penal Code, which talks about punishment for murder. It is said that the crime is committed against the whole society. Whenever a crime is committed, it is committed against the whole society. So the criminal liability will come here in the form of punishment. The criminal liability will come here in the form of punishment. Like for example, section 302 of the Indian Penal Code is talking about punishment for murder. Whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. Other penal provisions may also be applicable depending upon the cases. So if the person is guilty of committing the offense with criminal intention, then he is liable for punishment. Criminal liability is based on the maxim actus non facit reum nisi mens et rea. It means the offender is guilty only when it is done with the guilty mind. I am repeating this again. Criminal liability is based on the maxim actus non facit reum nisi mens et rea. It means what? It means the offender is guilty only when it is done with the guilty mind. Okay? So, the next point is penal liability. Penal liability. So, what is penal liability? The third point. The main purpose of penal liability is either directly or indirectly to punish a wrongdoer. The basic principle underlying penal liability is contained in the maxim just now that we have discussed, actus non facit reum nisi mens et rea, which means that act alone does not amount to crime unless it is accompanied by guilty mind. Therefore, two elements, that is act and guilty mind, action and guilty mind, are essential requirements to constitute a crime. No person can be punished merely because his act resulted into some crimes unless it was accompanied by mens rea, or we can say guilty mind. Conversely, mere presence of mens rea shall not constitute a crime. Mere presence of mens rea shall not constitute a crime. Okay? Mere presence of mens rea shall not constitute a crime or an offense unless it is accompanied by some act. Thus, act is the physical element of the crime, and mens rea is the mental element. Act is the physical element of the crime, and mens rea is what? It is the mental element. So generally, a man is held liable only for those wrongful acts which he does either willfully or negligently. So, the theory of penal liability is concerned with the punishment of wrong. The theory of penal liability is concerned with the punishment of wrong. A penal liability can can arise from a criminal or a civil wrong also. Criminal wrong like theft can give rise to liability in the form of imprisonment, which may extend to 3 years, or with fine, or with both, which is coming under section 379 of the Indian Penal Code as punishment for theft. So this is just an example. That is criminal wrong like theft, okay, can give rise to liability in the form of imprisonment, which may extend to 3 years, or with fine, or with both, which is getting covered under section 379 of the Indian Penal Code as punishment for theft. Now there are different kinds of punishment: deterrent punishment, preventive punishment, retributive punishment, reformative punishment, etc. Like nowadays we are following reformative punishment, which I have discussed in another video, administration of justice. Okay, so the act is called the material condition of penal liability. This is very important. The act is called the material condition of penal liability, and the mens rea is called the formal condition of penal liability. Okay, now let us come to the next point here: remedial liability. Remedial liability. So the remedial liability is based on the fundamental principles of ubi jus ibi remedium. That is, for every wrong there is a remedy. Whenever law confers a right, it also provides a remedy for the infringement of that particular right. So we can say the basis of remedial liability is to be found in the maxim that we have discussed now: ubi jus ibi remedium, which means where there is a right, there must be a remedy. When law creates a duty, it ensures what? It ensures its fulfillment also. Where there is a breach of duty, there must be some remedy prescribed by law and enforced by law. Let me make it clear now by citing one example. Like you are having a tenant is having the right of possession when it comes to the rights of the tenant. If there is a contract, let's say between the landlord and the tenant, that the tenant can stay there for 2 years, let's say, which was done through a mutual agreement. The landlord cannot come and ask for evicting the tenant before the agreement date is completed, that is before 2 years. The landlord cannot evict the tenant unlawfully. So here in this example, the tenant is having the right of possession, and as the tenant is having this particular right, when the landlord will infringe or violate this right of tenant, the tenant will get remedy in such cases. The remedial liability will be upon whom? The remedial liability will be upon the landlord to compensate the tenant for infringing his right. Now, as the tenant is having this right of possession, the landlord is having the duty to protect this right of the tenant by not infringing or violating it. So when law creates a duty, it ensures its fulfillment also. When there is a breach of duty, there must be some remedy prescribed by law and enforced by law. So if the landlord in this particular example infringed the right of possession of the tenant, the landlord caused what? The landlord caused breach of duty, or did not fulfill his duty to protect the right of the tenant. And for that, there must be some remedy prescribed by law and enforced by law. Thus, we can say the purpose of remedial liability is to ensure the specific enforcement of plaintiff's right. It aims at protecting the right of the plaintiff rather than punishing the wrongdoer. This is very important when it comes to remedial liability. It aims at protecting the right of the plaintiff rather than punishing the wrongdoer. Now, Let me make it clear. So now in this example, if the tenant file a suit against the landlord for infringing his right of possession, the primary aim of the court of law from the perspective of remedial liability will be to protect the right of the plaintiff. In this case, tenant is the plaintiff, rather than punishing the wrongdoer. That is, in this case, the landlord is the wrongdoer. Thus, the purpose of remedial liability is what? Is to ensure the specific enforcement of plaintiff's right. So according to the theory of remedial liability, whenever law creates a duty, it should enforce the fulfillment of such duty. So in this example, law created the duty for the landlord, and the duty is not to infringe the rights of the tenant. The law imposes remedial liability on one who fails to perform such duty. I am repeating this again. The law imposes remedial liability on one who fails to perform such duty. Here in this example, as the landlord failed to perform such duty, the law will impose remedial liability upon the landlord. Okay. Now let us come to the fifth point here. Vicarious liability. Vicarious liability. So vicarious liability is when one party is held accountable for the actions of another. Examples are master and servant, firm and partners, employer and employee. So vicarious liability, generally this relates to an employer's responsibility for actions by an employee when someone is injured or property is damaged as a result of an act that occurred during the employee's working hours. A parent may be held vicariously liable for actions committed by his child if another person is injured as a result of the child's actions. But this typically occurs only if the child is under age. For an employer or parent to be held vicariously liable, the victim of the act must have suffered injury or property damage that would not have resulted without the action of the employee or child, regardless of intent. So to make this concept of vicarious liability clear, let me cite one case law here. Lloyd versus Grace, Smith and Company. I'm repeating the name of the case. Lloyd versus Grace, Smith and Company. 1912 case. So in this case, Mrs. Lloyd had 2 cottages and she was not satisfied with these properties. So she approached the office of Grace, Smith and Company, and it was a firm of solicitors. The managing clerk, with a malafide intention, advised Mrs. Lloyd to sell the 2 cottages and to invest the money in a better way. The managing clerk asked her to sign 2 documents which were actually gift deeds. But she was told by the managing clerk of the firm that those were sale deeds. The gift deeds were signed by Mrs. Lloyd in the name of the managing clerk himself, which Mrs. Lloyd had no knowledge. The gift deeds were signed by Mrs. Lloyd in the name of the managing clerk himself, which Mrs. Lloyd had no knowledge. So it was a fraud done by the managing clerk of the firm and was done fully for his personal benefit. So the managing clerk then disposed of the property and misappropriated the proceeds. He had acted solely for his personal benefit and without the knowledge of his principal. So it was held in this case that since the agent, that is the managing clerk of the firm, was acting in the course of his apparent or ostensible authority, The principal was liable for the fraud. Ostensible means stated or appearing to be true, but not necessarily so. So, as the agent, though committed the fraud with Mrs. Lloyd for his own personal benefit, but being agent, he did it in his official capacity. But being agent, the clerk, the managing clerk, did it in his personal, in his not personal, in his official capacity, in the name of the firm. So the principal could not here refuse to compensate Mrs. Lloyd for the fraud caused by the agent of the firm. So as the agent, though committed the fraud with Mrs. Lloyd for his personal benefit, for his own personal benefit, but being agent, he did what? He did it in his official capacity, in the name of the firm. And that is the reason the principal could not here refuse to compensate Mrs. Lloyd for the fraud caused by the agent of the firm. Okay. Now let us come to the sixth point here. Absolute or strict liability. Absolute or strict liability. So, strict liability, sometimes referred to as absolute liability, is primarily found in cases of like defective products or services. Examples of strict liability include the manufacture of vehicles that contain an accidental flow that causes crashes or accidents, the manufacturing of let's say food products that have become tainted, resulting in illness, or components in certain medications that later are shown to pose health hazards and lead to illness or death. In most cases of strict liability, it is not necessary to show that the provider of the product or service acted with disregard or even negligence. It must only be shown that the product caused the harm. It must only be shown that the product caused what? The product caused the harm. Like, let me make it clear. Like, if you go to a restaurant, what type of food you will expect there? What type of food you will expect in restaurant? Good and hygienic food. But let's say if you have been served unhygienic food, and while consuming you had no knowledge regarding the quality of the food served in the restaurant, and later on it caused diarrhea, then the strict liability will be applicable to the restaurant owner. Strict liability will be applicable to the restaurant owner. The restaurant owner cannot come and say that he had no knowledge regarding the quality of the food, or it has been done due to negligence of the chef. Such excuses will not be considered in such cases related to strict liability. And the same rules applies for medicine companies. Like, if a particular medicine in its ingredients chart claims to have a certain component which later on has been found by the customer not present, which caused ailment to the customer due to this, strict liability will be applicable on the medicine company. Okay. So strict liability, that is the concept of strict liability or absolute liability, it evolved in India after the case M.C Mehta versus Union of India, 1987 case, famously known as Oleum Gas Leak Case. So this is one of the historic cases in the Indian judiciary. The case of M.C Mehta is based on the principle of strict liability, but with no exception were given, and the individual is made absolutely liable for his acts. It is based under this principle that the defendant won't be allowed to plead defense if he or she was at fault, as it was laid down in Ryland versus Fletcher case. So after the Bhopal gas leak case, Many people lost their lives and are suffering from some of the fatal diseases through the generation, and because of this there was an urgent need to develop a rule under strict liability which had no exceptions available to the defendant to escape from the liability. So the rule laid down by the Honorable Supreme Court of India in this case is much wider with respect to the rules laid down by the House of Lords in the case of Ryland versus Fletcher. So it was propounded by the Supreme Court that where an enterprise is engaged in a hazardous or inherently dangerous activity, and if any harm results to anybody on account of the accident in operation, the enterprise would be held strictly and absolutely liable to compensate to all those who are affected by the accident. Thank you.